Yes, Mr. Cordara.
My lord, I had reached the group of paragraphs in the judgment from 78 to 83. They are referred to by the learned judge as his second points. They are of the various points perhaps the most interesting in the sense that the learned judge deploys at a generic level certain procedural requirements which we glanced at briefly, and there's no need to reopen them, in the first few minutes of the appeal at or about page 22, enclosure 5 of the statutory material. And what he says about that is that I'm thinking particularly of 82 and 83 when I say this, but the point of entry is para 80. He says the substantive conditions included the insolvency condition and the property condition, and he makes reference to the amendment of the insolvency provision. So his lordship is embarking on an analysis very consciously in one alternative, including the provisions which are contrary to EU law in the sense that they are a bar to entry, which we now know was not lawful. And it is, in my submission, risky, to put it no higher, to include the presence of the unlawful provisions as a factor in a conclusion which ousts the application of a common law remedy of mistake, which has obviously a particular focus on the effect of unlawful conditions. It is not merely circular, but self-defeating, because to exclude, by reference to the erroneous material, the common law remedy for damage done by reference to its presence is, in our submission, obviously wrong. And what his lordship does, having said what he said at 80, reinforces that at 81 and says, in line with those domestic cases on ouster, which I referred to repeatedly beforehand, he says, I don't think that Parliament can sensibly be taken to have intended, when setting out these substantive and procedural conditions, that taxpayers could, without fulfilling them, have made a claim for a refund in cases where the customer did not pay in respect of a relevant supply. Just taking that sentence, not particularly out of context, but knowing that those conditions include the need to prove insolvency, this is not a conclusion, we say, that is remotely in line, if I may say so, with logic, let alone European law, for the reason I've just given. So I won't repeat that. He goes on to say there wouldn't have been any point in the statutes containing these conditions. Where one has lawful conditions, no problem, because Parliament sets out a system and one sees the force of saying that's the way it has to be done. But one can't include, in my submission, the unlawful conditions, which by definition could not be complied with.
What the judge is doing is looking for the intention of Parliament. What he says is when you're looking at the intention of Parliament, you look at what Parliament did. Now we know that it included the insolvency condition and the property condition. He goes on to point out that we now know that those don't pass muster under European law, but he says to ignore what Parliament actually did when working out what Parliament intended to do would be wrong. Now, can I, just to be sure I understand your point, can I see where this goes? The question before us is whether in 1978, by virtue of Section 12 and the regulations, Parliament intended that structure to be the only way to access bad debt relief if it turns out your customer hasn't paid you what you billed them for. Now, in the context of this particular case, that resolves itself as being whether Parliament excluded common law remedies, the Woolwich remedy and the mistake remedy, which are not EU remedies at all, they're common law remedies. The fact that the conditions that Parliament put in place infringe EU law, why does that affect the inquiry as to whether Parliament intended to exclude a common law remedy?
May I give a three-step answer?
Yes.
First of all, the first step, acknowledged as I would have the force of this organisational point, which is made in many an ouster case. You've got these steps. Step one is to say, fine, but confine the scope of the ouster to the words on the Queen's printer's page. Then there's a counter, which is moulding. We're in an EU law area. Therefore, we can broaden those. Answer, the Court of Appeal has held, indeed, that that can be done. So the ball is batted back. We return the ball at this point, third step, by saying, fine, let's go European. At which point, you can't, we say rhetorically to our imaginary opponent, you can't pick which bit of European law you like, moulding, which say...
I don't read the judge in this passage of addressing the moulding question at all. What I read this passage as doing is saying, Parliament obviously intended to comply with EU law. We now know, everybody now knows that Parliament didn't get it right. But what you're looking at is Parliament's intention in 1978, intended to set up a compliant bad debt relief scheme which contained, as the directive allowed it to, conditions and derogations and so on and so forth. The question is whether when doing that, that was intended to be exhaustive and exclusive, or whether it was intended to leave room for parallel common law claims, whatever they might be. That question, as I read it, has got nothing, it's not affected by how you might mould it and whether it's really available and whether it could have been available and so on and so forth. It's to do with what was Parliament trying to do? Trying to set up one of two parallel schemes for bad debt relief, one statutory and one common law, or was it trying, by stepping into this area, to set up the only scheme for bad debt relief? And as I read it, the judge's point is, well, when it's set up a statutory scheme which has lots of conditions attached to it, that's a reason for thinking this wasn't intended to be in parallel with common law rights. It was intended to be the only route. The fact that they didn't get it right doesn't affect that question. And that's got, as I read it, nothing to do with the fact that you can adapt and mould the scheme, as the Court of Appeal said in 2014, to enable you to access your directly effective rights. It's just to do with what Parliament thought it was doing when it started. But am I wrong in reading it that way?
Well, no, I see that if one just looks at 81, it's certainly not the case if we look at 82 and 83, where
yes, but that is, but even if, yes.
Let's stay on 81. I essentially the answer to my Lord's intervention is yes, but stay domestic in that case, and by stay domestic I mean you've asked a domestic law question, you haven't included any European law input into the question. And my tennis analogy, which I think you saw where it was going, was either stay domestic, in which case the ouster point is not a problem for my client because the ground covered by the Queen's Printer's version, 1978, did not cover my clients. I do not think it's the Crown's argument, but we'll see, that notwithstanding that ex facie didn't cover my client, we're still excluded. I don't believe that to be the Crown's case, and the Crown's case is the moulded-based case. And I realize I'm not directly answering the question, but it's important that I am clear.
Sorry, I think I've missed that point. You say the printer's version doesn't apply to BT. Well, obviously it doesn't, but that's the point.
Well,
it's a much narrower scheme.
Exactly, and therefore I'm assuming, perhaps wrongly, that it won't be suggested that an unmoulded version, Queen's Printer's version, ousts the mistake claim.
No, I'm not sure that's the question.
Well,
anyway.
The alternative way of looking at it, well, if I can just deal with my 1, 2, 3 point before I forget it. So we're saying stay domestic, fine. Once you expand the gateways to the scheme by moulding, before you've used that against the taxpayer to say, well, you had your chance, it's been abolished, end of story, and you can't come back and ask for more. Before you do that, you must take the broader EU approach, and by the broader EU approach, I mean exactly the approach which led one to mould. In other words, this is too narrow, we have to give direct effect, we will mould it. But do not then say in the next breath, but we're going to have a full-blooded ouster as well, because all you do is draw the taxpayer onto the haunts of disaster, because obviously you've drawn them into an abolished provision. So start to mould by all means, but don't then take the extra step which is now on the table, which wasn't on the table in the Court of Appeal, and say, and there's an ouster, because at that point one cannot possibly justify that as furthering the agenda of giving directly effective rights. So that's my possibly non-answer to a question. Returning to the question, I would say this. By all means, as a first step, do that internal inquiry at Section 81. The logic of it is, it doesn't really matter what was in the box legislatively in the Queen's Printer's version, as long as it had old scheme, wouldn't have had the word old, debt scheme, whatever, then Parliament had put a marker down that anything that might or might not be in that box at any time, plus stuff that may not be in the box, would all be ousted, because Parliament has simply said, we've occupied this ground, we've got a scheme for these 4 or 5 words in Article 11C1. It's an inadequate scheme or not, we don't know yet, it's 1978, we're not sure. But inadequate or adequate, it's ours. And all common law remedies, including if we get it wrong, we Parliament get it wrong, are off the table. That's a tough agenda, you will decide. But one of the powers you have is to say, and I'm repeating myself and I apologise, I won't do it again. Well, if that was the agenda, then that was contrary to European law, and we, sitting in 2023, are not going to advance that agenda. So that's para 81. Para 81.
Thank you.
Para 82 and 83, I'll take a little more quickly. His Lordship, and really this, in my submission, supports what I've just been saying about just putting a box in place. 82 is on one premise, 83 is on another. So at 82, His Lordship says, no doubt with great respect, correctly, in line 5, Parliament must be taken to have intended faithfully to implement European law when it introduced the old scheme, and when assessing whether Parliament intended to enact a comprehensive and exclusive domestic scheme for refunding tax and non-payment of debts, it seems to me that the court should not disregard those elements which have turned out to infringe the requirements of European law. I would submit that his lordship is now taking that extra pace, which perhaps I wrongly accused him of taking 81. And I've made my submission that you can hardly include the offending provisions as a reason for ouster. You can include non-offending provisions, that's what he does next, but one can hardly include the offending provisions. I made my submission there. On 83, and he says, but even if this conclusion is wrong, when assessing Parliament's intentions, one should approach the old scheme stripped of the offending elements. It appears to me that the other elements of the old scheme point firmly towards a parliamentary intention to create a comprehensive and exclusive statutory scheme. And the only observation, so that rids the process of what I have said is unacceptable. But the difficulty is that it's not clear, or it doesn't follow, that the material that he then identifies, that is to say, at paras 84, 85, 86, and 87, are sufficient either in a common law context, or more importantly, in the context that FII 2012 puts us in, to enable the court with confidence to say that there has been an ousting which would survive the examination under the light of EU law and effectiveness, because it is ultimately that which his lordship doesn't do, but which I invite this court to do. Whatever the solution, it has to go through, in my submission, that final check. So, just taking this very rapidly now, at 84, his third point, he mentions an appellate system. That is, one would think, always going to be true of taxing statutes and refunding provisions therein. There will be an appellate system. The question is it for any reason preferable to a common law system? And we say the ingredients are likely to be the same. Of itself, it is, we say, insufficient. The fourth point, para 85, quantum, para 7 of the regulations. That, of course, has the insolvency process embedded implicitly in it. And in any event, quantum would be the same under both common law and any statutory system. Fifthly, at 86, refund where there is a subsequent recovery. Again, that would be taken into account in the context of a mistake claim, and even if final judgment were given on a mistake claim, it would be expected that there would be a requirement to adjust in the event that debts are paid. 87, sixthly, which I haven't fully followed, I must confess. It said in 87 the procedure under the old scheme was expressed to be separate and distinct from the statutory procedure for restitution of overpaid tax in Section 80 of that Act 1994 and its predecessors, which would be Section 24 of the Finance Act 1983. The short point there is neither of those was on the statute book in 1978. It was an entirely common law landscape, and even after 1978, this is a fresh point, we've made it in writing.
When you say neither of those, you mean Section 80 and its predecessor?
Correct, my lady, and by, as I say, that's Section 24.
Yes, FA 89.
So there was another 4 years to go before there was any kind of, or there was those kinds of. So, and I'm not only pointing that out, I'm saying, and there was a landscape, or would have been, if anyone had known about the mistake of law possibility, a common law landscape. And then seventhly, we have debated already, para 88, the significance, if any, of section 39.5, and you have my submissions there.
I didn't understand your reference to another 4 years.
78 to 83 is, of course, not 4 years.
But in any event, did it come in 83?
No, I think it was 89.
So section 24 you referred to.
Yeah.
1990.
It was 89.
Starts 1990.
Yes, I should stay away from figures of any kind. Yes, now they've had a much better point, and I'm grateful. For 11 years.
Another 11 years.
Yes, I'm grateful. So those are our submissions. On the judgment, we've had a look at the context of para 88. My just Warby's question. It appears to us that it's entirely said in the statutory context in which we were operating, and answering the questions that the Court of Appeal. There was no debate, ouster, and no one touched upon common law matters. Apart from,
Sorry, that's a reference to BT in the Court of Appeal.
Forgive
is
me,
it?
yes.
Yes.
I'm just going to turn around for the usual purpose, if I may. I have nothing to add.
Thank you very much. Yes. I'm sorry,
Borrow some.
I'm not sure how to pronounce your surname, and having suffered from it myself, I think it's very rude to mispronounce.
Mitrofanus.
Mitrofanus.
Thank you.
Yes, Miss Mitrofanus.
Well, if you could just bear with me for 1 moment. Thank you. Just to point out at the outset, as in our skeleton, I'll refer to the first 9-month period. It's of course the subject of issue 3 as the 9-month period, and the 10-year period, which makes up 98% of the claim, as the main claim period. And of course, issues 1 and 2 go only to the main claim period. For various reasons, it's important to keep the issues separate, primarily for analytical clarity. But if I may, the court will indulge me, I'd like to start off by outlining what was established in the statutory appeal, looking at all 3 issues. I appreciate that your lordships and your ladyship have looked at BTCA, but I just want to go through the key points because it's important to identify what's not open to my learned friend to re-argue. And just before I forget, one point, for example, that I wanted to correct is that in response to my ladyship's question regarding paragraph 118 at BTCA, where my learned friend said that the Court of Appeal was discussing the availability of common law remedies, it's in fact, as I'll show the court when I go to 118, referring only to the 9-month claim period. The important point being that in the 9-month claim period, there was no old scheme. So there was no question of ouster.
Can I just clarify one point on that? I think the judge says below that HMRC don't rely on a sort of reading back of the old scheme into that 9-month period. Is that your position on appeal as well, or is there a bit more to it?
Could I answer it this way? There are a variety of points we might take if the case goes on.
I see.
But for the purposes of strikeout, we selected obviously points that we think are so strong that they show that my learned friend is bound to fail.
Right, so you'd present purposes,
Absolutely.
you don't rely on the old scheme in any respect for the 9-month period.
No. And that's why I said at the outset that issue 1 and issue 2 concern the main claim period. So when I say the old scheme is an exclusive remedy, I mean in the main claim period. And as I've said, that's not to say I'll never say it, but for the purposes, it's obviously a more difficult argument to make that it had retrospective exclusivity.
Yes.
I want to take on, strike out the strong arguments, which I say show that the case is bound to fail, and so I take the point that for the main claim period it's exclusive. So then if I could start, and I'll take this quite briefly, but I just want to show the court the upper tribunal decision in 2012. And that's at Authorities Volume 4, tab 43. Page 1005. Now, the upper tribunal was considering first GMAC's appeal, which was heard jointly with BT's. And what it does is look at the GMAC position in a lot of detail and then adopts the reasoning when it comes to answering the BT questions. So if I could take it at page 1005 from paragraph 163, we start by asking whether GMAC's claim is properly to be treated as made under section 22 by the old scheme. That section contained ... the unlawful conditions. On the footing that those conditions are incompatible with EU law, the question then is whether GMAC's directly enforceable rights should be given effect through the mechanism of section 22, but with some appropriate moulding to reflect the invalidity of those conditions. Dropping to 165, in the present case, UK domestic legislation, section 22/old scheme, did provide for a form of bad debt relief in the shape of the old scheme. The old scheme was intended to reflect the obligations of the UK under Article 11C. On the hypothesis now under consideration, the property condition and the insolvency condition were impermissible restrictions on the right to relief. But that does not detract from the fact that section 22 was the mechanism by which bad debt relief was to be delivered. We see no reason why the approach of the cases just mentioned should not be applied to GMAC's claims. For BDR, as we see it, section 22 can and should be read as providing the mechanism for giving effect to GMAC's directly enforceable claims. Where there's partial or total non-payment within the meaning of 11C1, section 22 is to be read as providing relief in relation to that non-payment by disapplying the insolvency condition. Mr. Cordara says in his skeleton that there is no way in which section 22 can be read as covering GMAC's claims. That succinct submission no doubt reflects what the tribunal recorded him saying, namely that section 22 could not be made compliant with EU law by reading words such as without prejudice to the directly enforceable community rights, because that would go against the grain of section 22. Just pausing there, the court will hear the echo from FII 2012, where the Supreme Court, Lord Sumption and Lord Walker, said to read section 33 in a compliant way would go against the grain.
Well, Lord Walker expressly talks about going against the grain, doesn't he?
That's right. Lord Sumption uses more colourful language.
Yes.
So even the highly muscular Marleasing approach is described as doing radical surgery to the provision.
Yeah.
And of course, and this is my learned friend made that argument, but by saying here it would go against the grain. Like the tribunal, we consider that section 22 can probably be seen as the mechanism by which effect is to be given to GMAC's directly enforceable rights to bad debt relief under the directive. So we say those passages are important. The upper tribunal setting out there that the purpose of the old scheme was to give effect to Article 11C1 rights in relation to non-payments, point I'll come back to for issue 1, and that it was indeed possible to mould the old scheme, to read it in an EU law compliant way. And that's important because it's a recognition that doing so would not go against the grain, that the old scheme could properly be moulded. If we just go through to page 1026, I could just show the court quickly the position regarding BT. Just paragraph 235, the preliminary issues raised in the BT matter raise substantially the same questions as those which we've discussed in relation to the GMAC appeal. And then they go on to explain that there is this difference of the 9-month claim, that GMAC didn't involve any 9-month claim at all. Now, as the court will be aware, what the upper tribunal decided was that the repeal of the old scheme by section 39(5) of the 1997 Finance Act had to be disapplied to give effect to BT's rights. But that was reversed, the only aspect I think that was reversed by the Court of Appeal. And then I don't know if my learned friend will come on to do something with this, but just to correct something again in his skeleton argument in case he does later. The final paragraph I want to go to is what's said about the claim that BT made to HMRC on the 30th of March 2009. In my learned friend's skeleton served last week, one of the opening points made at paragraph 3 is that and I quote, the statutory process got it wrong in considering that BT made a claim under the old scheme and that in fact it was a Fleming claim, i.e. a Section 80 claim. I think by the statutory process, my learned friend must mean the courts, i.e. the upper tribunal and the Court of Appeal, and of course that's not a point that's open to my learned friend to make. It's then said immediately after, again in paragraph 3, and I stress this because it's important.
Sorry, just where does that go? Is there something in the statutory appeal that says this was was treated as a bad debt claim under the old scheme?
Yes. Is
that the basis on which the appeals proceeded, or what?
As I say, it's not quite clear to me what my learned friend will make of this point, but it's important to correct it. It may come up later when discussing whether it's an overpayment claim or not.
Okay.
So statutory appeal decided that it was an old scheme claim. It was not a Section 80 claim. My learned friend says in the same paragraph in his skeleton, and I stress completely inaccurately, that it's common ground that BT made a Fleming claim, Section 80 claim. As I say, I'm simply correcting at this point in case something is done with that point because it is inaccurate and not open to my learned friend.
So you're treating Fleming claim as equal to a Section 80 claim, but I mean Fleming just refers to the opening of the floodgates when the time limits were found to be unlawful.
Yes, but the Fleming case itself involved input tax, and there was I think it was Marks and Spencer's case involving output tax. The points were the same. What the UK had done and what was impermissible is that it had changed the limitation period from 6 years to 3 without
under Section 80.
Yes.
I see.
Without a transitional period.
Yes.
So you think you have a claim on Monday that you can hold until Friday, and on Tuesday you're told it's gone.
Okay.
And without a transitional period.
Yes.
And Fleming, sometimes called the Fleming window, because inspired by the Fleming case, as it were, was Section 121, where both for input tax and output tax, a transitional period was given. You have a year. You taxpayers have roughly a year from for these old supplies that would have been caught in this retrospective unlawfulness, as it were.
Thank you.
So yes, Fleming is synonymous, at least for our purposes, with Section 80. So just again, if I could just briefly correct the point, we'll see it at paragraph 242 to 243 of the Upper Tribunal decision, endorsed by the Court of Appeal. So 242, just taking it very briefly, we do not, for the reasons given in GMAT, we do not consider Section 80 applies at all. Since the mechanism for giving effect to BT's directly enforceable rights was to be found in Section 22. And then they say there was no time limit for making such a claim until Section 39.5 came into force. And that, we say, is actually a good way to look at it. Yes, there was no limitation period, but 39.5 came along with sufficient notice of repeal and brought the shutters down on the ability to claim. And then just dropping to 10 or so lines before the end of paragraph 242. So far as we can see, no claim was made by BT for relief under Section 80 before 1st of April 2009. That's the closing of the Fleming window, or indeed at all. The claimant letter dated 30th of March 2009 asserted a right to a refund. The whole thrust of the letter was that the insolvency condition was invalid. Further, a mistaken view was taken as to the repeal of Section 22. Complaint being made that bad debt relief in respect of pre-89 supplies was being abolished. That complaint was misconceived, but the fact that it was made indicates BT's case was that relief should be granted as precisely that, namely bad debt relief. There was no suggestion Section 80 had any role to play, or that there has been a payment of an amount which was not output tax due.
Presumably the Court of Appeal didn't, I can't recall them commenting on this, you're saying?
They do, they said, sorry, my lady, I jumped in too quickly with an answer.
Thank you.
Paragraph 127, which I'll
Right,
get to in a
thank
minute.
you.
So if we turn then to the Court of Appeal decision, it's bundle 4, same bundle, tab 45, page 1086. As I say, I'll take it quite quickly, but I do want to pick out some key points which go to a number of the issues in various ways. So just the first few lines of paragraph 1 at page 1091. 30th of March, BT wrote to the commissioners making a claim for hitherto unclaimed VAT bad debt relief for the period January to March 89. That's for a period ended 20 years before the claim. And then 2, domestic legislation relating to claims for VDR in respect of supplies made during that period, the period March 89 to was Section 22 of VAT 1983. And then it sets out an outline of BT's letter. BT's letter suggested it had, during the currency in force of Section 22, made claims for relief in cases where such conditions were satisfied. Its March 2009 claim was for relief in respect of cases where they were not. Its case was advanced on the basis that it had directly enforceable European Union law rights to relief in such cases with which Section 22 conditions, in particular the insolvency condition, was said to be incompatible. So clearly BT's argument was that the old scheme of repeal had to be disapplied because otherwise BT would be denied its EU law rights. Sorry, I've jumped too quickly. If the court would just read to the end of paragraph 2. That was the thrust of BT's complaint. We've got directly enforceable rights, disapply the repeal of the old scheme so that we can actually have effective protection of those rights. We see at the beginning of paragraph 9, the court say at page 1094, finally and by way of introduction to the legislative story, the appeal is centrally about the alleged incompatibility of elements of the national legislation with what is said to be BT's entitlement to enforce its directly enforced effective EU law rights under the directive, and how, in the case of any such incompatibility, the court must deal with the problem. So squarely before the court in BTCA was what are BT's EU law rights and what did they need in the event, as was in fact held to be the case, the old scheme insolvency condition was unlawful. And then the Court of Appeal goes through the legislative landscape in detail. And I'll turn to the provisions of the old scheme myself in detail when I look to issue 1. But if I could just show the court very quickly that these schemes, the old and now the new scheme, are all subject to a claim being made. So we see that at paragraph 17, by P shall be entitled on making a claim to the commissioners to a refund of the amount of tax chargeable by reference to the outstanding amount. And then section 12 was replaced by section 22, and that was in fundamentally the same terms. That's noted at paragraph 25. And then at paragraph 29, the court sets out the first version of section 80, which was section 24 of the 1989 Act. And paragraph 30 is particularly important because it was adopted by the court, and this is common ground, and it's particularly important for issue 2 when we come to it. By way of anticipation of the arguments on the cross appeal, Mr. Lasoc's responsive submissions was, the cross appeal was a section 80 claim. Mr. Lasoc's responsive submission was that section 24 and its successors, i.e. all the other section 80s, have nothing to do with claims for bad debt relief. They were and are concerned only with cases in which an overpayment of tax had been made to the commissioners and provide a restitutionary basis for the recovery of the excess. In a bad debt case, there was no payment of VAT that was not due, or therefore any overpayment of VAT. And this next sentence is all important as well. Failure to make a bad debt relief claim in a subsequent return, i.e. a failure to set off, did not mean that there was any overpayment in the tax actually paid. If no relief claim was made, the tax paid was the tax due.
Is that all recording Mr. Lasoc's submissions?
It's recording Mr. Lasoc's submissions.
Which you are going to say later were accepted. But this is not decision by Lord Justice Reimer. This is just at this stage setting out the Commission's argument.
And just while the question is fresh, can I give the short answer to it? When we come to paragraph 127, we'll see that all that Lord Justice Reimer says, and for the reasons given by Mr. Lasoc, and so on. So this is the only reason recorded. So it's always been understood that paragraph 30 is adopted.
Yes.
But the additional reason I'm very comfortable in saying that is that in the recent upper tribunal decision, my learned friend himself made the submission that paragraph 30 had been adopted by Lord Justice Reimer. Yes. And what you see when you get to the upper, which we'll get to in a second, what you see when you get to the upper tribunal decision of 2023 is paragraph 30 is actually described as being Lord Justice Reimer's conclusion because of this adoption process.
Yes, thank you.
Sorry, I'm a little lost as to where it was that the submissions recorded in paragraph 30 were accepted and adopted.
Paragraph 127, which I'll come to show you, Your Lordship, if that's
I was
right.
just looking at it and I can't see that, but you'll show us. Don't worry, don't take time. Just come to it in your own course, your own course.
Mr. Lasocq supported the upper tribunal's reasoning, and I too agree with it.
This is all under the heading of the cross appeal.
Yes,
that
section
is
80.
clearly specific to the cross appeal. The cross appeal is about the application of section 80.
Yes.
As I understand it.
And so is paragraph 30. We'll get into this a little more detail with issue 2, but what's being said in paragraph 30 is BT has no claim under section 80 for statutory restitution because at no point did it overpay tax. All the tax it paid was due. When a trader doesn't access the optional bad debt relief scheme by making a claim, the trader hasn't thereby overpaid tax in any way. It's simply not accessed relief.
This is really issue 2. But
It is issue 2, but
there's quite a lot of discussion in Mr. Cordara's response skeleton of the difference between something being due as a matter of administrative machinery and what he calls the underlying amount of tax that ought to have been paid, what the base really ought to have been. I don't want to take up time now, but there is a real question as to that issue, whether this is really paying more tax than you should have done or not.
in my submission there isn't really an issue.
Yes. Your point is if you don't make a claim, then your tax remains due.
It's not my point, it's the statutory appeal has decided if you don't make a claim, the tax paid is the tax due.
Yes.
In section 80, it just talks about over-accounting for tax, overpaying for tax. It doesn't say in a technical sense. It is the statutory mechanism for restitution. If a trader pays tax to HMRC that is not due to HMRC, as a matter of domestic law or European law, it's section 80 they go to, just to give your lordships, your ladyship
Yes.
a simple example, but it's an everyday example in the VAT world. You have the UK saying that a supply is taxable, i.e. the domestic regime saying a supply is taxable. EU law, under EU law, properly understood, it's exempt. And you have a Court of Justice decision saying actually that supply is exempt. What does a trader do? They've accounted for tax on the basis that it's taxable, and they now realise that it was exempt. They use section 80 to get that tax back. It's not technically due to HMRC or non-technically due. It's due or it's not due. Do they have a liability to pay it? Not under EU law. Section 80 gives them a remedy. When the Court of Appeal says under the cross appeal, you don't have a Section 80 claim, that means that, because what is a Section 80 claim? It's BT saying, I accounted for tax not due, or I paid for tax not due. The Court of Appeal says, no, you didn't. But I have more answers to the recent skeleton and the way it's set up, because some of the points made about Article 11A in my submission need correcting, and to the extent that my learned friend relies on Avico, as we'll see, all this has been decided in the statutory appeal and can't be reopened. So I hope to show that as I sort of whiz through the statutory appeal, if that's all right.
But rationalising it, I take your point that this is what the Court of Appeal has decided, but rationalising it would be that unless and until you make a claim, your underlying liability, it isn't a mere matter of machinery, your liability is to VAT is calculated without that claim being taken into account.
The BDR claim.
Yes.
Yes, so just sometimes it's Section 80.
Yes.
Yes,
so,
absolutely.
So
absolutely.
I think you would say, consistent with the approach you say the Court of Appeal took, that a bad debt claim can't be characterised as mere machinery, whatever that might involve. But we're anticipating.
Yes,
later submission.
absolutely. If you don't make a claim, then the tax paid is the tax due, because it's optional. You don't, by failing to make a claim, thereby account for more tax than you should have. And Regulation 38, just in case question on that later, is different. Regulation 38 was the choice that the UK made in relation to price reductions. And what it decided to do there is make it mandatory. So in the case of a price reduction, you shall reduce the taxable amount, and your partner shall reduce their
Input.
Yes. So that's different from the BDR way of the route taken by the UK for bad debt relief, which was an optional claim to relief. There was no you shall reduce. It was you're entitled or making a claim to relief. But we'll come to that, and helpfully I think the recent upper tribunal decision makes a lot of that clear. And then the court just outlines I'm just continuing with the BTCA case, as I've called it. The court next goes to the introduction of the new scheme, which does not cover the claim period. And just to note, paragraph 31 on page 1102, apologies, page 1101, it's section 11, subsection 2, subject to the following provisions of this section and to the regulations under it, the person shall be entitled on making a claim to the commissioners to a refund and so on. So that's always how bad debt relief has been done. And if I could just summarise the paragraphs dealing with how the old scheme came to an end, because it was in two stages. When the new scheme was enacted in 1990, Schedule 19 of the 1990 enactment repealed Section 22, repealed the old scheme, but only in relation to supplies after it came into force. For BT's case, which concerns supplies made before 89, the old scheme remained in place, remained an option for another 7 years. So there was a sort of early warning sign in 1990, and then in 1997, the shutters came down. If you'll note, that's setting it out really at paragraph 42. And that's why one of the key questions in BTCA was whether the upper tribunal had been right to say that section 39.5 had to be disapplied in order to provide a remedy for BT. The upper tribunal decided it had to be disapplied. The Court of Appeal decided it didn't. We didn't have to resuscitate the old scheme. And this is important because BT's rights under EU law had been sufficiently protected. And again, while we have it open, if I could just show the court very briefly, again, some submissions that will be seen echoed in my learned friend's most recent skeleton. So we have at paragraph 52, page 1106, reference to the case of Glorspiel. Sorry, that's my error. It's Article 11A1A at 52, at 53 Glorspiel. Towards the end of that page, we see Elida Gibbs. Now, my learned friend succeeded, of course, in the Court of Appeal 2014 in showing that 11C1 was directly affected. But it didn't succeed in showing that BT had paid any amount not due. Any amount not due as a matter of EU law. So, again, please bear that in mind when I come to issue 2, where my learned friend in his recent skeleton again goes through Article 11A1A, Elida Gibbs, and so on. And as we know, BTCA decided that the insolvency condition was unlawful. For your note, that's 71 and 72. And then, briefly, paragraph 75. This is the court considering preliminary issue 1, the old scheme had to be moulded to give effect to BT's rights, but that the old scheme but of course the old scheme had been repealed. So if we pick it up at 75, the upper tribunal's discussion about this commenced at 160. Their view was that the National Court had to provide a remedy for directly effective rights. That's the general principle, that the court must of course provide a remedy. Sorry, I'll put that a little more carefully because there's an important dispute between my learned friend and myself. Of course, there has to be effective protection of directly effective rights. But that doesn't mean that you have no limitation periods or that you can't repeal with sufficient notice the old scheme. Or that if the old scheme train is missed, as my learned friend puts it, that EU law demands that another remedy be provided, or that the old scheme mustn't be seen as exclusive or anything of the kind. EU law doesn't demand that a second remedy be provided. What EU law requires is that the exercise of directly effective rights are given effective protection. So the principles of equivalence and effectiveness. It's not virtually impossible or excessively difficult to access those rights. By the trader. So an example of an instance of virtually impossible or excessively difficult, or in fact impossible, is the retrospective changing of a limitation period, the retrospective shortening of a limitation period without a transitional period.
Marks and Spencers.
Yes, and Fleming, hence Fleming window. The ending, the lawful ending of an old scheme, doesn't make anything virtually impossible or excessively difficult.
As long as you signal beforehand, that's what you're going to do.
And BTCA decided that that had happened. And of course, if that hadn't been the case, they would have had to disapply the repeal of the old scheme or find some remedy. I'm sorry, I interrupted myself. I was at paragraph 75. National Court had to provide a remedy for the directly effective right and would often be able to do so by appropriate moulding of its legislation. 165, they said that, these are the paragraphs I took the court to, they said that even though the old scheme's insolvency condition imposed an impermissible restriction on the right to relief, Section 22 was nevertheless the domestic provision by which bad debt relief was to be delivered. It had therefore to be read as providing a mechanism for a directly effective claim. It's to be read as if it provided such relief by disapplying the insolvency condition. Pausing there, if we turn, I think the next paragraph that we need to look at is 87. Yes, above that we deal with a 9-month claim, which I'll come back to, but 87 on page 1117. As regards supplies made from October 78 to March 89, i.e. the main claim period, BT was entitled to make bad debt relief claims successively under Section 12, Section 22, i.e. the old schemes, in cases in which it could satisfy the insolvency condition, that in such cases it can make its claims either in its VAT return for the accounting period when it received the requisite insolvency document or a subsequent return, although the latter indulgence was removed in 91. Time limits for making such claims were indisputably governed by the provisions of Section 12 and 22, which said nothing about time limits, and the regulations made under them, which did. I've summarised that. No one has suggested there was anything wrong with those time limits for the purpose, from the perspective of EU law.
What were the time limits under the regulations? I missed that.
It was at a certain point, it was you could make the set off in any subsequent return. Then at some point, I think through HMRC, it was said that it had to be in the return when the insolvency document was received. But any regulations that had to do with the insolvency condition, the upper tribunal said had to be disapplied also.
Okay.
BT could, as I would hold, and had it grasped the point in time, also have made claims under Article 11C1 of the Directive for Bad Debt Relief, in all cases whether or not the insolvency condition was satisfied, on the basis that the insolvency condition was unlawful and incompatible with its EU law rights. The only procedural way in which it claims it was then entitled to do so was by way of an appropriate adaptation and moulding of Section 12, Section 22 in the regulations, so as to accommodate the rights it was exercising, which ought to have provided for them in the first place. And then the next sentence is to do with one of the arguments in BTCA that's not an issue for us is whether HMRC was saying, well, in the absence of a limitation period, EU law implies a reasonable limitation period, and they were unsuccessful on that point. If we drop
That passage you just read, before those words,
yes,
supports your first proposition that the claim that was being advanced by BT was under a moulded version of the statutory scheme and not otherwise.
and then if we drop to 91. I set up preliminary issue 2 at 5 above, and the upper tribunal's answer to it at 6. This is whether you disapply the repeal of the old scheme, I resuscitate it. The premise of that issue was that the affirmative answer under preliminary issue 1 in relation to BT's EU law rights was of no value to BT if the exercise of those rights was anyway barred by 39.5. The question under preliminary issue 2 was whether 39.5 had to be disapplied or construed in such a way so as not to affect BT's exercise of its EU rights. And again, just pausing there, this is the whole thrust of BT's complaint, mirrored here today. Not only was the old scheme unlawful, but by the time anyone told us it was unlawful, it had gone off the statute books. What about our EU law rights? What about our directly effective 11C1 rights and so on? To which the answer is directly effective rights. There is no EU law right for directly effective rights either to go on forever, as in to be able to access it without limitation period, as long as the limitation period or the ending of a scheme is done in a compliant way. And also, as we'll see, limitation can run out even before a trader has realised or even been told by the CJE, for example, that it has a claim. And when that's appreciated, then one can see that BT's complaint runs rather hollow, because it doesn't have any EU law right to once BTCA said the insolvency condition was unlawful, to then have a remedy given to it or opened up for it, or exclusivity denied in order that it can have a remedy and so on. And then the court considered arguments that BT had sufficient warning of the ending of the old scheme, first by, as I said, that sort of two-stage, first in 1990 and then 1997 when the shutters came down. There was also further months' notice in the budget. And then the court says at 105 at page 1124, just in response to that, Mr. Lassock reminded us that in addition to the changes introduced by the FA 1990, the consequential 9191 regs and guidance, by way of change to the previous practice, required any claims for relief under the old scheme to be made in the return for the tax period when the relevant insolvency document was received. they could no longer be made in any subsequent return. Mr. Lassock said the circumstances introduced by these changes made it clear to any prudent and circumspect operator there would necessarily come a time when any claims he had or might have had under the old scheme would come to an end, following which there was a likelihood the old scheme would be repealed. Prudent and circumspect operator does not in such circumstances do nothing. He may have a considerable volume of small bad debts arising from his pre-April 89 supplies, and for him to do nothing may be to find that the old scheme had been repealed before he has done what might be open to him. As a prudent circumspect operator, he will have known for years of his directly enforceable EU law rights, or at least that he had a good arguable case that he had such rights, and will know also that any such rights will have to be enforced under the umbrella of Section 22. He doesn't, he'll foresee that a time may come when there may be material adverse change in the law with regard to claims under Section 22, and it will be too late for him to make his claim. Mr. Lassock pointed out that the evidence was that BT destroyed documents relating to bad debts 6 years after they arose, which he said was not the conduct of an operator relying on the expectation it could make a claim at any stage in the future. This is Justice Ryman. I regard those submissions as compelling. My intuition is that there is something inherently wrong in BT's complaint that, from March 97, Section 39(5) unlawfully deprived it of its right to enforce its directly effective rights under 11C1. It had had since 78 the opportunity to enforce those rights in respect of each and every bad debt as it arose, and was entitled to claim in doing so that the insolvency condition was invalid. By March 97, it is likely that all its debts arising from its pre-89 supplies were either paid or statute barred. The only reason that it had not taken steps to enforce its directly effective rights is, so I presume, that it was unaware of them. Ignorance of one's legal rights is not, I should have thought, a sound basis on which a bid can ordinarily be made to disapply legislation that has eventually put a stop to their future exercise. And I think my learned friend, in answer to the court's questions, has clarified that that's what he says the mistake was. It was unaware that it could do what it eventually did in 2009. Made a mistake and ran out of time to bring a claim under the old scheme. And then we come to the key conclusions in BTCA, picking it up at 118. To 128. And, just as a sort of marker, 118 is the 9-month period. 119 to 124 is BT's EU law rights and whether the repeal of the old scheme had to be disapplied in order because of the need to protect directly effective rights. And 125 to 128 is Section 80. So taking period, so paragraph 118, taking first the period 1st of Jan to 30th September 78, we had some generalised discussion about this during the argument, but it did not distinguish between types of cases referred to at 116 and 117. Given my overall conclusion in respect of the main part of BT's claims, namely that part relating to supplies made during the October 78 to 89 period, are regarded as unnecessary to deal separately with those two types of case. Either they are blighted by the... Sorry, I should pause there and explain what 116 and 117 were in the two types of case. What the upper tribunal had done as regards the 9-month claim is to say, well, if the bad debt arose after October 78, even though the supplies were before October 78, that would come into the scheme, potentially.
Yes, that's because the old scheme applied to insolvencies after October 78.
Supplies after 78 was the key. Okay. Supplies made from October 78. But in any case, it's just to explain what they meant about 118, that they were potentially two different classes of case in that 9-month claim. I regard it as unnecessary to deal separately with those two types of case. Either they're blighted by the same problem as relates to the main claim, or else the only right that BT ever had to claim relief in respect of these bad debts was a common or restitutionary claim, long since statute barred. what the court's saying there is for that 9-month claim, it's either, as the upper tribunal thought, swept up into the old scheme, and we'll go on and explain what the problem with that period was, blighted by the same problem, or if it's not swept up into the old scheme, what BT had was common law claim and restitution with a 6-year period, limitation period. Obviously,
A woolage claim? Is it a woolage claim, or what sort of claim is it?
well, anything but a mistake-based claim, so it wouldn't open up section 32(1)(c), which is the extension to the 6-year period. But of course, to be fair, this is the statutory appeal, so it's not that this court was deciding whether they had a common law claim or not. But it's expressing the view that it's either coming under the old scheme or it's a common law
It
claim
didn't
with a
have-
6-year
yes, I see.
limitation.
I see. Yes.
We don't. That's its view, but it's not as though that it was open.
And put
to
it another
deciding
way,
it.
HMRC aren't relying on that reference to 6 years.
No,
in
no.
any way.
No, the reason I
Yeah.
stress it is something different. I think I heard my own friend say this morning, and I hear it sometimes in his skeleton, the idea that, well, BTCA recognised in principle that we had a common law restitutionary claim.
But your point is this is only for a 9 months period.
Absolutely.
And they're not saying that there was a restitutionary claim. What they're saying is this is a statutory appeal. So in order to bring yourself within a statutory appeal, you have to have a statutory claim. And if you've got a statutory claim, it's just like the main period. If you don't have a statutory claim, you might have another common law claim, but that is going to be statutory barred. But we're not concerned with that because we're only dealing with a statutory appeal.
Right, and as I say, to be fair and to submit the right thing, I can't rely on them to say, oh, they found it was only a 6-year common law claim. The reason I stress it is because I don't want, as I said, my learned friend sometimes says the BTCA decided they had a common law claim in restitution. That BT had a common law claim in restitution, or said that it acknowledged that it might have a common law claim in restitution, or anything along those lines. And it's just important to recognise that that was said in relation to the 9-month claim, not the main claim period. Is that clear? Okay, so that's the 9-month claim. And the critical paragraphs 119 to 123. Could I just invite the court to read 119 to 123, please? And note in particular around 122 and 123, the strong terms in which the position is expressed by the Court of Appeal. It had been open to BT to use the old scheme. It had every opportunity to get advice. And of course, this is the court that found that the insolvency condition was unlawful and that BT had rights were directly affected. And yet its conclusion was not what my learned friend would like it to be. But the insolvency condition meant that I couldn't access it. I haven't had effective protection of my EU law rights. Its conclusion was the insolvency condition was unlawful. 11C1 is directly effective, but it was open to BT to make a claim under the old scheme because that's how it works. On its proper construction, mar least, this is what the old scheme meant. And there's no requirement under EU law that a remedy has to be kept open until somebody establishes that you have a right to it. That's why the court didn't disapply the repeal of the old scheme, as it would have had to do if there hadn't been effective protection of BT's rights. The court will see why I'm emphasising this point as we go through the issues, but one of my learned friend's refrains is, but I have to have effective protection of my EU law rights. The old scheme can't be my only remedy, i.e. exclusive, because I have to have effective protection of my EU law rights. My mistake-based, turning to issue 2, my mistake-based unjust enrichment claim must work, must be made to work, or I won't have had effective protection of my EU law rights. That, with respect, is wrong. Effective protection of your EU law rights does not preclude a remedy being exclusive or require the ending of the old scheme to be disapplied, scheme to be resuscitated, or a remedy to be found for you. The requirements are the dual simple requirements. Has the UK made it virtually impossible or excessively difficult to access your rights? No. Had it done so, the Court of Appeal would have had to resuscitate the old scheme to give effect to BT's rights. And we'll see all that echoed in a case my learned friend I think doesn't refer to in his skeletons, which is GMAC in the Court of Appeal, which was decided soon after this.
Will you give us the reference for that?
GMAC Court of Appeal?
Yes, which bit of it? Are you referring to a particular paragraph?
Yes, it's. I'll go to it.
Thank you. That's fine.
Particular 133 to 134.
Yeah.
I think I've listed it as suggested reading on our skeleton.
Thank you.
Basically come to the same conclusion. BTCA is more important because there's a res judicata, obviously. But
yes,
still, 2 Court of Appeal authorities, we say, deciding that BT's rights did not require, under EU law, anything further than what it had, which is the old scheme. And I think this is going to a question that was put to my learned friend, or an issue that was raised. It's right that BTCA did not have the exclusivity question before it. We know the questions it had before it. It was preliminary issues 1, 2, and 3. However, it's critical to note that it did consider that BT had directly effective EU law rights, and of course BT was arguing there, as it does here, that these are to be given effect. And the whole basis of BT seeking disapplication of the repeal of the old scheme was that they could be given effect through the old scheme. And that's why the court's answer to that is critical, repeated, as I say, in GMAC. There was no need to disapply the repeal of the old scheme, to resuscitate it, because having the old scheme claim remedy for the decades prior to its lawful repeal was sufficient protection of BT's EU law rights. So, although the question of exclusivity wasn't before the court in BTCA, when I say in this court, as I'll say when I focus on issue 1, the old scheme was exclusive. Look at its statutory features and so on. We say it's exclusive. My learned friend's answer is, and one way he sort of puts it in his skeleton is, well, okay, it sort of looks exclusive, but it can't be exclusive in this case because that exclusivity or that implied exclusivity would interfere with my EU law rights. I.e., if all I had was the old scheme, and therefore didn't have it because it's been lawfully repealed, if that's all I had, that wouldn't be enough. And although the exclusivity question wasn't before BTCA, that part was. That important part of if all I had was the old scheme, that wouldn't be sufficient protection.
This is, in your submission, a decision that the rights were not, the EU rights which BT had, were not virtually impossible or excessively difficult.
Absolutely. And
hence you can bring them to an end, because the old scheme being open from 1978 to 1997 gave you almost 20 years in which you could assert your rights, and that's enough.
yes.
Yeah.
But yes, full stop. The additional point I want to stress is that although the exclusivity question wasn't before BTCA, in saying what it did, it was saying that if all you have is the old scheme, that's enough. Because after all, if the old scheme was not enough,
then you would have had to do what the upper tribunal did and disapply the termination.
Absolutely. So,
or provide some other remedy. But no other remedy was being suggested. That was what was being asked for, which was to
well, no, there was in the cross appeal. We'll see. BT said,
oh yes, we've got a section.
disapply the, resuscitate the old scheme for me.
Yeah.
Cross appeal. It's a Section 80 claim. I've overpaid tax.
Yeah.
And when my learned friend got to the Court of Appeal again in GMAC, there were further requests. Section 80, or perhaps we can make the new scheme apply retrospectively. And they all go to, I have to have something because I was kept out of my money because of an unlawful condition.
Yeah.
But the answer to all those please give me something remedies, and today it's, I must have my mistake of law restitutionary claim not ousted by the old scheme, is that BTCA makes clear that BT has sufficient protection of its EU law rights. And it's critical to remember that the Court of Appeal said that, well aware, because these were its own findings. When the Court of Appeal said you have effective protection, we're not going to resuscitate the old scheme, it was aware of one, Article 11C1 had direct effect. The Court of Appeal itself confirmed that. 2, that the insolvency condition was unlawful. After all, the Court of Appeal itself confirmed that. 3, that BT had not brought a claim under the old scheme in time, i.e. prior to its repeal, because it was unaware that it could do so. That BT, in other words, had made the mistake. 4, and this is important too, the Court of Appeal was aware that the old scheme had been repealed long before any court said that the insolvency condition was unlawful. It had been repealed in 1997, and the Court of Appeal was confirming in 2014 that the insolvency condition was unlawful. Despite those 4 points, the court rightly concluded BT's EU law rights had been sufficiently protected.
Well, whether it's right or not, it's what's been decided in this case.
Yes, between these parties.
Yes.
And reiterated in GMAC, this isn't a question of, well, you know, you're stuck with it, but it's not a great decision, but you're stuck with it. It's a it's a straightforward decision, if I can put it that way, because what directly effective rights require is that they be given effect, but a member state can have, because of the other important principle, legal certainty, limitation period can, with appropriate warning, can repeal, as here, the old scheme. And BTCA made clear BT had plenty of time to bring a claim under the old scheme, albeit that it would have to question the insolvency condition, and had no cause for complaint when the option was repealed with sufficient notice. And the court wasn't saying that thinking, oh, but, you know, I'm saying this because we know that there's some common law claim waiting in the wings. My learned friend rightly pointed out this morning that Court of Appeal wasn't even told there was. Everyone, I think, had forgotten about it by 2014 because it had been brought in 2010 and then had been stayed pending the statutory appeal. So it's not, there's no plausible reading at all of the Court of Appeal's decision being, oh, we won't resuscitate the old scheme because we think you've got something else. So someone else will give effect to your EU law rights. It was clearly saying the old scheme was sufficient and then just before we leave BTCA, (125) to 128 is the Section 80 position, which is relates to issue 2, and as I've said, we say, and it's common ground, but it also adopts paragraph 30. I could summarise that now and come back to it for issue 2 if that's easier, just to move on to the issue 1 insolvency condition. Exclusivity issue.
Just by way of a yes or no answer, does this point that you've been making very forcefully have an impact on issue 3, the limitation argument? I think that's issue 3.
Effective protection of...
in a very simple-minded way, if BT had years and years and years no excuse for not exploiting the rights which it should have known it had, you might say, well, it's got absolutely no chance of getting away with an extension of the limitation period.
Well,
and if you don't say that, then I'm not sure where this point goes.
Well, the extended limitation period requires a mistake, and what I say, and again I'm taking the points that I think I can get home on
yes.
the strikeout without difficulty, not every point that I might take otherwise, is that my learned friend can't identify a relevant mistake. So the old scheme we can forget because on this hypothesis for the strikeout it doesn't apply to the 9-month claim. What happens is, what's BT got? A common law claim with a 6-year limitation period. What mistake did it make? It failed to bring a claim by the end of the 6 years. My lord, I think, put the question to my learned friend earlier and has the point. Missing a limitation period is not the basis of
well, in
claim.
a sense, if you've got a claim against somebody and you don't bring it, that can be said to be you made a mistake. You didn't bring the claim, but that's not
relevant.
That's not the relevant mistake. The relevant mistake is you believed something to be the case and it wasn't the case. And I put to Mr. Cordaro what the false belief was, and I understood it entirely in relation to the main claim. He said the operative mistake was that the old scheme was justified in excluding those who had not gone through an insolvency procedure. That doesn't apply to the 9 months claim, because that's a mistake about the old scheme.
But the parallel for the 9-month claim will be, no doubt, yes, I had a 6-year limitation period because HMRC were holding money that I should have got under the correct interpretation of EU law. Living aside the old scheme, this is the 9-month period. HMRC had money that was due to me. They had that at my expense. And I should get that back. What's the normal limitation period? 6 years, unless you can identify a mistake. What's your mistake, Mr. Cordaro? My mistake is that I didn't bring the claim by the end of 6 years. So I didn't know I had it or whatever. I mean, I'll come to this in issue 2 and touch on it on issue 3 again, but it's the same point for both of these issues. It's simply, with respect, nonsense to say that when somebody misses a limitation period by mistake or otherwise, that grounds a mistake-based unjust enrichment claim. So let's say I have 6 years to bring a claim against my learned friend for £10 that he owes me. And for whatever reason, I don't bring it within the 6 years. I didn't know the law, mistake of law. I didn't know I had 6 years. Made a mistake of fact. I thought I'd done it last week, but it turns out that I hadn't. Whatever the sort of mistakes and beliefs I can have, when I fail to bring that claim and the 6-year deadline hits, I haven't been enriched at my learned friend's expense.
Other way around. He hasn't been enriched at your expense. You
Sorry,
failed to bring...
Sorry, yes. Oh, no, sorry. Yes, because, and this is why you have your 6 years. The reason I can get the £10 back is because I've got a right to restitution, but I don't get some further right once I miss the 6-year deadline. Because I missed the 6-year deadline, of course, my learned friend's better off because I didn't go after him in time. But that doesn't count as enriched at my expense. I'm sorry if I've got my parties the wrong way around. I'll be clearer when I go to issue 2, but that's the fundamental point. If my learned friend's claim, I think, is clarified that it is, either by 1997, I missed the old scheme train, or for the 9-month claim, after 6 years, I missed the common law restitutionary Woolwich type claim, the deadline, because I didn't know that I could bring a claim, mistake of law. That doesn't ground a claim in unjust enrichment. There isn't some defective transfer of value when I don't bring my claim within the limitation period. The defective transfer is the one I have a claim for in the first place.
I think rather than
But
explore this now, we'll come back to it when we come back to it, because I think there's some very fundamental questions as to the nature, both of what the mistake is and to what extent a mistake can cause a transfer of value. There's the Deutsche case, and which Mr. Cordaro places a lot of reliance on, but I don't want to disrupt your flow at this stage.
Yes. So
you were drawing attention to 125 to 128, which deals with Section 80, but you don't want to say any more about it at the moment?
no, I think that's fine, because we'll get a summary of it when I come to the last step in the statutory appeal, which was the recent May 2023 decision. And if I can ask your lordships to turn, and your ladyship, I apologise, to turn up the GMAC case I mentioned. The court will recall that in the upper tribunal, BT and GMAC were together, and then they split apart for various reasons that are irrelevant. BT came to the Court of Appeal in 2014, then 2 or 3 years later, GMAC.
They sent a reference off to Europe, didn't they?
Yes, but for a windfall issue that's not relevant to
Yes.
our proceedings. It's volume 5, tab 49, page 1206. If we pick it up at paragraph 118, page 1240. Could I ask the court, it's actually easier if just to read 118 to 124, listening out, as the court does that, for echoes of the recent skeleton argument.
Where do you want us to go down to? 124.
124, please. So there, my learned friend is having lost in BTCA when asking for the remedy of resuscitating the old scheme. When it came to the GMAC Court of Appeal, asked for other remedies. Could I have a new scheme retrospectively apply? Or could it be regarded as a Section 80 claim because, after all, GMAC had directly effective rights? And we see the court's answer to that, and this is the critical decision. It's paragraphs 126 to 134. I'm afraid it's a bit more to read again. And we rely on paragraph 126, where the court endorses the point made in BTCA that the unlawful condition isn't the basis for setting aside the whole scheme, but just the basis for moulding it, for disapplying the unlawful condition. And so, of course, the lawful part of the scheme, including that it was a scheme that allowed for optional claim to relief, remains. We also rely on paragraph 130 that the ending of the old scheme was like the alteration of the time limit. It terminates the right to claim relief, which is fine if done with adequate notice. And we know that it was done with adequate notice because BTCA said so. We rely in particular on paragraphs 133 to 134 for the point that BT's rights, like GMAX, were not rendered excessively difficult by the ending of the old scheme. And that was said in particular in the context where my learned friend was arguing that some other route had to be found for GMAX, such as retrospective application of the new scheme or through Section 80. And of course the final point, again repeating BTCA, tax paid was due, and that didn't change when a bad debt arose.
At that stage, the Court of Appeal had not decided the Iveco case.
No, but importantly, at the time of the Iveco case, it had, or Justice Newey had before it, GMAC, Court of Appeal, BT Court of Appeal. The point was made and noted in the decision that bad debt relief is different because it's always something that you've had to claim.
Whereas Regulation 38
Yes,
was mandatory. Yes.
when it came into being, it was mandatory. In fact, Iveco dealt with, just to correct my learned friend, Iveco considered Regulation 38 in argument, but the actual period was more like a 9-month period. It was a 10-year period where there had been no provision made for, or at least a 10-year period where there had been no provision made at all in the case of price reduction. Now, I don't plan, unless I'm corrected, to go into Iveco in detail because of the last piece of the jigsaw that I'm going to go to. Because what happened next was, because Iveco in the Court of Appeal was decided, my BT thought that this gave its statutory appeal new legs. And they could say, but Iveco said something different. And so we do have a Section 80 claim. BTCA was only looking at Section 80, subsection 1, but really we've got a claim under subsection 1B and so on. That's why the statutory appeal continued, but it is now over. In May 2023, the upper tribunal upheld the strikeout of the statutory appeal, i.e. considered but Iveco's changed things, and Justice Newey refused permission on the 28th of September 2023. So it's over, and the reason I stress it in those terms is because so much of my learned friends, or quite a large part of my learned friends' recent skeleton, seeks to revive Iveco. And I don't yet see how that's possible when in the statutory appeal, which is no permission, it's over, set of proceedings, it's been decided that Iveco doesn't change.
Again, this is not issue 1, this is issue 2.
Yes, it'll be issue 2, but as I say, the reason I'm going to the statutory appeal is to show how various points have been decided already, and that will help us when we come to answer 1, 2 and 3. The Iveco point is issue 2, possibly issue 3, but it's not exclusivity, yes. So if I can finally go to the most recent upper tribunal decision in the upper tribunal.
Of course, the issues which went to BTCA were simply preliminary issues in a statutory appeal. So the appeal itself continued afterwards.
Well, no,
and then someone applied. Did you apply to strike it out? Or?
Well, yeah, yes, we did. But perhaps we'll see it in the upper tribunal decision. But if I can give the short answer of the chronology. Yes, 3 preliminary issues went up. First to the upper tribunal to join GMAC, and then to the Court of Appeal. when the Court of Appeal said what it said, and I've just taken to what it said, it seemed clear to us that it was over.
Yes.
Because you're out of time. Yes, the insolvency condition was unlawful, but it's been lawfully repealed, the old scheme, and it doesn't have to be resuscitated. So what could they be left to argue about? So it's not that the appeal continued; it's that BT tried to continue it in the first tier tribunal, and we said, how can this continue? There's no issues of fact or anything that's going to change the fact that the appeal is over. We won on that in the first tier tribunal. Then my learned friend appealed to the upper tribunal, and that was the May 2023 decision.
Yeah.
So it's not preliminary issues. It's you have no, you know, it's over.
Well, I think you did apply to Star Account.
We did, yes, but successfully.
Yes.
Yes.
Well, with no permission to appeal. So it's not as though there's something continuing, and it's just the preliminary issues that have been finished with. There's nothing continuing. The appeal has been struck out. With no permission to appeal. So if we could go to volume 7, tab 64. Page 1924. If we just pick it up at page 1927, I'm just going to show you section 80 briefly, just to make sense of what the decision then says. So section 80, subsection 1, where a person has accounted to the commissioners for VAT, the prescribed accounting period, and in doing so has brought into account as output tax an amount that was not output tax due, underlined, the commissioner shall be liable to credit the person. That's a section 80 claim under section 80, subsection 1. Then over the page, subsection 1b, where a person has for a prescribed accounting period whenever ended, paid to the commissioner an amount by way of VAT that was not VAT due to them otherwise than as a result of ... an amount that was not output tax due and so on, the commissioner shall be liable given to repay to the person the amount so paid. So
I haven't understood what 1B is addressing, because I thought the VAT you paid to the commissioners was output tax.
It is, and there have been debates about exactly what 1B covers, and does it cover what my learned friend says has gone on here. So the output tax was right, but by failing to make a set-off, i.e. a bad debt relief claim, that comes within 1B, or is it that 1B is just there for arithmetical errors or as a catch-all? But whatever the position, my learned friend sought to continue on the basis that Iveco gave 1B legs, and also that the Court of Appeal in BTCA, by referring to Section 80 in general terms, had not considered 81B. And that's the gateway through which my learned friend sought to continue the appeal after BTCA. And I'll show you the court now that was definitively off. So, paragraph 35 on page 1931. BT submits its claim for bad debt relief has not been finally resolved by the answers given by BTCA to the 3 preliminary questions. It submits that there remain open issues for determination by the FTT. In particular, BT submits that the answer given by the Court of Appeal to question 3 of the preliminary issues does not address whether BT's letter, 30th of March 2009, can be construed as a claim falling within 81B, and whether a claim under Section 80 is time barred. Mr. Cordaris admits that there are 2 routes by which Section 80 is engaged in relation to bad debts. First is that in accounting for output tax on customer bills that subsequently go bad, BT is making a retrospective overpayment of VAT for the purposes of subsection 1. The second is that BT was entitled to make a claim under Section 81B because the VAT arising on a bad debt would automatically, underline, be set off against payments made in subsequent accounting periods, so that the subsequent payment would be in part an overpayment. Mr. Cordaro acknowledges that the Court of Appeal decided BT could not rely on Section 80, subsection 1 to make a claim for repayment of overpaid VAT. See the judgment of Lord Justice Reimer at 125 to 127, and then they set that out. And then 38. However, Mr. Cordaro submits that the Court of Appeal said nothing about Section 80, subsection 1b, and its decision needs to be read in the light of its subsequent decision in Iveco. Mr. Cordaro submits that HMRC's position in BT's appeal is inconsistent with the position they adopted in Iveco, where they successfully argued that Iveco's analogous claim had to be made under Section 80. The taxpayer in Iveco was a trader selling commercial vehicles. The taxpayer gave a discount to its customers depending on the number of vehicles purchased during a specified period. The discount was effected through a rebate mechanism at the end of the period. Thus, the output tax recorded on the taxpayer's VAT return for the VAT accounting period in which a vehicle was sold would correctly reflect the undiscounted price paid by the taxpayer for the vehicle at the time of supply. However, because of the eventual rebate to the customer, there was an overall overpayment of output tax. Mr. Cordaro submits BT's position is analogous to that of the taxpayer in Iveco, and that BT correctly accounted for output tax on the supplies made to its customers in the VAT accounting period in which the supply was made, but because of the failure of some customers to pay their bills, there was an overall overpayment of output tax. And then over the page at 42, Mr. Cordaro submits that in Iveco, the Court of Appeal held that 1, there was a direct dialogue between Article 11C1 and the taxpayer's state of account with HMRC. And pausing there, again, the echo in the recent skeleton of the rolling account. There was a direct dialogue between Article 11C1 and the taxpayer's state of account with HMRC, conducted without reference to the state of any domestic legislation. B, given the inherent retrospectivity built into Article 11C1, it will always operate retrospectively to adjust the taxable amount without any need for the taxpayer to make a claim. C, it achieves this retrospective adjustment by means of rendering subsequent, otherwise due payments of VAT not due. They become overpayments, notwithstanding that the original payments were due when originally paid. This is the provisional initial payment in my learned friend's recent skeleton. Section 81 or subsection 81B are engaged as a consequence. And E, because the taxpayer's rights under Article 11C1 are directly effective, the implementation or non-implementation of those rights into domestic law is of no relevance. And then 45. Finally, Mr. Cordaro submits the Court of Appeal's judgment in Iveco covered all elements of 11C1, including unpaid debts. As such, they are the principles that govern this case, even if they are inconsistent with those applied by the same court in its determination of the preliminary issues. Failure by the Court of Appeal in BT's appeal to address the Section 80, subsection 1b point limits the scope and effect of its decision to this case. Mr. Cordaro submits the failure by the Court of Appeal to address Section 80, subsection 1b point leaves it open and means we can follow Iveco for the purposes of the appeal before us. We do not agree with Mr. Cordaro. Mr. Cordaro acknowledges that he made submissions on the application of Section 80, subsection 1b before the Court of Appeal. They were also raised in BT's application for permission to appeal to the Supreme Court. Just adding there that was obviously rejected. We find that the court did in fact address BT's submissions on the engagement of both 81 and 80 subsection 1b in its judgment. Lord Justice Reimer's judgment at 125 to 127 addressed Section 80 as a whole, possibly because preliminary issue 3 is phrased by reference to Section 80 as a whole, not by a reference to its individual subsections. It would have been strange if the court had not responded to Mr. Cordaro's submissions. At 125 to 127, Lord Justice Reimer held that Section 80 is not engaged in relation to claims for bad debt relief, and we read his judgment as referring to Section 80 as a whole, including 81 and 81b. Although the old scheme did not give effect to BT's directly effective rights because of the insolvency condition, it was nonetheless the prescribed or accepted mechanism for giving effect to 11C1 in respect of claims for bad debts under domestic law. In those circumstances, we find that EU law principles required BT to make its bad debt claim under the domestic regime, but suitably moulded to give effect to the taxpayer's directly affected EU law rights. In the case of BT's bad debt claims, it was straightforward to mould. So not radical torture, straightforward to mould the domestic regime by eliminating the insolvency condition. Moreover, this was the express finding which Lord Justice Reimer made in the Court of Appeal at 88 in answer to preliminary issue 1. And then 88 is set out. 49, the same requirement for the moulding of domestic law can also be seen, for example, in the judgment of Lord Justice Henderson in Repertoire Culinaire. And this is a case I might come on to if there is time. It's mentioned in our skeleton. Following a referral to the CJEU, it was determined that the UK's implementation of an EU exemption from excise duty for cooking wine was too restrictive. Lord Justice Henderson determined that the appropriate mechanism to give effect to the appellant's directly effective rights was that it should have made a claim under the relevant domestic regulations, but disapplying the irregular provisions. The potential for Section 80 to be used as a mechanism for making claims for relief for bad debts was also considered by the Court of Appeal in GMAC. It's not disputed that the key deficiency in the old scheme, at least as regards BT, was the insolvency condition, which failed the EU requirement of proportionality. This was discussed by Lord Justice Floyd at 126 to 134, pausing there. Those are the paragraphs I took the court to. Who also confirmed that bad debt relief must be claimed under the old scheme, appropriately moulded and not under Section 80. Almost there. Paragraph 51, page 1938. In Iveco, Lord Justice Neary considered the decisions of the Court of Appeal in both BT and GMAC and expressly referred to the paragraphs from Lord Justice Floyd's judgment, which we have cited above. Confirmed at 38 that bad debt relief does not arise automatically, but has always been something that a creditor must claim. In other words, absent a claim by the taxpayer, bad debt relief does not arise. We also reject Mr. Cordaro's argument that Section 81B was engaged, even if Section 80, subsection 1 was not. He faces the difficulty that subsection 1B applies to payments to HMRC of an amount by way of VAT that was not VAT due to them, otherwise than ... But in BT's case, output tax was properly due and charged when the supply was made. Mr. Cordaro's answer to this point is that an automatic set-off takes place between VAT currently due and VAT no longer due on the bad debt in a prior accounting period, and that an overpayment arises when BT makes a payment in a subsequent accounting period. He described this as a kind of statutory magic, which is brought about by Article 11C1. However, Lord Justice Reimer specifically addressed and rejected this argument in the Court of Appeal at paragraph 30. Pausing there, this is the explanation I gave, that 30 had been adopted by the Court of Appeal by Lord Justice Reimer, and this was common ground in the statutory appeal. This is not this part of the upper tribunal's decision is not controversial. And we see in a bad, just reminding you what 30 says, in a bad debt case there was no payment of VAT that was not due, or therefore any overpayment of VAT. A failure to make a bad debt relief claim in a subsequent return still did not mean that there was any overpayment in the tax actually paid. If no relief claim was made, the tax paid was the tax due. Further, adding there, just to foreshadow what I'm going to say on issue 2, not just technically due full stop. Further, in both Iveco and GMAC, the respective appellants submitted that Section 80 produced an inconsistency of treatment because it applies to price reduction cases, but not to bad debts. In both cases, the Court of Appeal rejected that argument and held that there was no such inconsistency. Article 11C1 expressly provides that Member States can determine conditions to give effect to the reduction in the VATable consideration. And the inclusion of a requirement in domestic legislation for a claim to be made is both consistent with Article 11C1 and not disproportionate. We agree with Mr. Beale, Mr. Beale was for HMRC, that there are good reasons for the different treatment of claims for bad debts and claims for other reductions in the amount of consideration. For example, in the case of bulk discount rebates, it's clear when the reduction in the consideration occurs, i.e. in price reduction cases, it's clear when the reduction in consideration occurs. But the same cannot be said for the timing of the reduction in consideration due to a bad debt. There may be many reasons why consideration may be left unpaid, and a debt does not become bad purely as a result of its non-payment. Moreover, the precise timing of recognition is usually a decision for the creditor. It's for these reasons, therefore, that the bad debt regulations do not prescribe a specific time at which the consideration is reduced, but rather for the taxpayer to determine whether the debt is bad and then give the taxpayer an option of claiming relief. We find in relation to its main claim, BT should have claimed bad debt relief under the old scheme, moulded to give effect to the requirements of the Sixth Directive. We also find the Court of Appeal decided the issue, rejected the argument which Mr. Cordaro also advanced before us. 57. We are satisfied, therefore, that both the upper tribunal and the Court of Appeal determined the 9-month claim, just as, sorry, I've taken that too quickly. I could ask the court, I lose my voice, just to read from 55 to 57. That's the position on the 9-month claim. And then the final two paragraphs are 63 and 65. Sorry, 63 to 65. And I've gone to that upper tribunal final decision fully because in my learned friend's original skeleton for this appeal, in footnote 4, my learned friend concedes that he can't run the IVCO point again, but in the recent skeleton of last week, it seemed to us, at least, and my learned friend will explain, but it seemed to us that there was an impermissible attempt to rerun the IVCO arguments, which, as I say, have been definitively decided against BT. So no overpayment, over-accounting of tax, even taking into account how IVCO dealt with the position regarding the...
Did you want to show us what Lord Justice Nugee said when refusing permission to appeal against that decision?
Yes, it's in the core bundle, tabs...
Supplementary bundle, I think, isn't it? Or am I wrong?
Sorry, supplementary bundle, tab 6, page 27. Permission to appeal refused, and I'll invite the court to read the reasons.
Yes.
Of course, the same applies here. Same parties, separate proceedings. Issue stuff. we'd understood that that was accepted, as I say. So, as we said in our skeleton, there are a number of matters not open to my learned friend. To stop from arguing them, I think in our skeleton we set out a number of these as common ground because that's what we understood to be the position. But if it's not common ground, we'll say in any case issue estoppel. Just to list them in the last few minutes. 1, the purpose of the old scheme. Parliamentary intention in enacting the old scheme was to give effect to Article 11C1 rights. Upper Tribunal, paragraph 165.
Sorry, is that the original Upper Tribunal?
Yes,
decision?
sorry, I should have been more
So
careful.
UT 2012
12.
at 165.
Yes. Reflected in paragraph 2 BTCA. 2. The old scheme could readily be moulded to give effect to Article 11C1 rights by doing away with the insolvency condition, and that was the right approach. Upper Tribunal 2012 163 to 166, BTCA 119 to 123. Three, that BT did not know that the old scheme could be moulded was irrelevant. It had every opportunity to bring a claim under the old scheme, challenging the insolvency condition. The exact quote was, BTCA was, ignorance of one's legal rights is not a reason for disapplying the repeal. 4, the repeal of the old scheme did not therefore interfere with BT's legal rights. They'd been sufficiently protected. And those points are again in 119 to 123 of BTCA and in GMAC 133 to 134.
133.
133 to 134 of the
Thank
GMAC
you.
Court of Appeal decision. 5, BT did not pay tax not due at all, including in a subsequent return after the bad debt arose, and when it didn't set off. That's paragraph 30 that I've been emphasising, and just generally 125 to 127 of BTCA. 6, IVECO did not apply to BT's circumstances. That's the Upper Tribunal 2023 decision.
Can I just be sure I understand? We're obviously not bound by what the Upper Tribunal decides as a matter of precedent, but in this case, you say there's an estoppel by the Upper Tribunal decision which can't be taken any further because permission's been refused. So even though it's only Upper Tribunal, the parties are bound by it, even though we're not bound by it.
That's right. So I say we win either way, as in...
As I understand, all the points you're just listing out are, you're saying issue estoppel points.
Yes.
They may be binding in another sense, but
That's
you're
right.
making them as issue estoppel.
Yes.
If we weren't here on BT but Trader X, I'd be saying BT Court of Appeal, GMAC Court of Appeal, you've got authorities against you. Upper Tribunal not binding on the Court of Appeal, obviously, but taken into consideration and so on. But as we're here against BT, I say precedent where it's possible, i.e. the Court of Appeal decisions, I say issue stop and res judicata for everything else I've listed. If there's anything I've missed off the list, I'll make sure to add it tomorrow. I'm about to focus on issue 1. Would the court rather I stop there? Happy to start 5 minutes earlier tomorrow, simply so that we don't start an introduction to issue 1 and then have to sort of be reminded tomorrow. I'm completely in the court's hands.
What would you rather do?
Just see what my first points are. I think I'd rather stop simply because I'm going to start explaining an idea and then
Yes.
it gets to the end of it, as it were.
And you'd like to start at 10.
If the court would like
Yes.
to.
Yes, we will start at 10.
Recommend.
Are you doing all right on the timetable?
I will make sure that overnight I adjust my submissions so that I finish in time. But as I say, some of those points that I've been making submissions on today will go to all issues and will make it easier when I come to dealing with issues. As I'll say, already decided. when I
Yes.
can.
Thank you both very much.
Court rise in favour.
Yeah. Oh, I haven't got that long, have I?
No, no,
Past
true, you
four.